Good afternoon and welcome to episode number 49 of At Your Service with Haber and Martinez. I'm Haber, that's Martinez, and we're here today to do our show called My Cousin Vinny, Absurd Comedy or Trial Reality, with our special guest, Vincent LaGuardia Gambini, Esquire. Now, Joe Pesci's not actually joining us on the show, but we're going to show you a bunch of clips from the movie. So let me start by saying this. If you have not seen My Cousin Vinny, if you've been living under some kind of a rock since 1992 or on another planet, don't watch this show right now. Go watch My Cousin Vinny and then watch this show later. For those of you who have seen the movie, very little introduction is needed. It's become a classic film, amazingly acted and performed by Joe Pesci, who plays a Brooklyn-based, fledgling, brand new personal injury attorney who gets called out to conduct his very first trial in rural Alabama on murder charges for a relative, nonetheless. It also stars Marissa Tomei, who plays his girlfriend/fiance, who actually earned an Academy Award for her performance, Best Supporting Actress. And then one of our favorite old actors, Fred Gwynne, plays Judge Chamberlain Haller, who gives a brilliant performance as well. The reason that we're doing this is, and it's kind of an experiment because we're going to show you a lot of video. So there's going to be about 20, 22 minutes of video and only about 35, 40 minutes of Ed and I, which I guess many of you will appreciate. But part of the reason that we're doing it is kind of as an experiment, because if this works really well, there are a lot of other really wonderful movies that we can use as jumping off points to have other types of interesting discussions. In terms of courtroom drama, stuff like To Kill a Mockingbird, 12 Angry Men, A Few Good Men, just to cite some examples. All right, I see Ed is smiling, and that means I've been talking too long. So let's go ahead and get started. And if you could cue up video clip number 1, we will talk about the fact that My Cousin Vinny, our first point that we're going to make is that arrests occur, and sometimes they're by mistake. Sometimes it's a legitimate mistake, an understandable mistake, but a mistake that needs to be exposed and can only be done through research. Okay, go ahead and cue up video number 1 up to the 40 mark.
A funny thing happened to William and Stanley on their way to college.
At what point did you shoot the clerk?
They got framed for murder.
Whoa! Wait a minute!
Now, 2 kids from New York are in deep trouble.
It's time to make your phone calls.
The clans here, they're inbred. They sleep with their sisters.
In the deep South.
Some of them do.
And only one man can save them.
We need to call an attorney, a great attorney.
He's not your typical hero.
We got an attorney in the family. Great, who?
He's
My cousin Vinny. You stick out like a sore thumb around here.
Oh, yeah, you blend.
You graduated from law school 6 years ago. What have you been doing since?
Okay, you can kill that video now. Thank you. All right, so Ed, let's talk about this point number 1. I'm going to give us about 3 minutes on each subject here. Arrests happen. Sometimes arrests happen by mistake. That's the entire premise of this movie, right?
Absolutely. And it actually isn't even by mistake. Let me explain it so that we can, if you think about the law and the burden of making the decisions, cops are probable cause. So the mistake may be that it can't be proven beyond a reasonable doubt, or it could be legitimately that the person's 100% innocent. But at the end of the day, arrests are made. It doesn't really necessarily mean that the person is going to be prosecuted, because their standard is it more probable than not that the crime occurred? And once you're in court with the prosecutors, beyond a reasonable doubt. So things happen. And cops don't always have all the information, but they try to do the best they can. Even the good ones make mistakes.
I think that's the real key point here. In this case, the sheriff made an arrest. And if you guys have seen the movie, you understand. The car was identified, the make, the model, the 2 young white males, everything kind of lined up. And so the police make an arrest based on probable cause, which obviously gets compounded with a little more evidence, which you're going to see in our next clip. But in this case, can you say that Sheriff Farley acted in bad faith? No, you really can't, because he was called out to a crime scene. There was a dead body. They identified subjects who were on the scene. And then when they interviewed those subjects, as we'll see in our next clip, they developed further probable cause. Although, again, I do want to point out one thing about My Cousin Vinny. One of the things that really makes it so fabulous is that the director, Jonathan Lynn, who directed this film, is a Cambridge Law School graduate. He knows his law, and they were very certain with casting and production and writing to try and make this as true to life as they could, given the fact that it's a Hollywood fantasy.
And you might be surprised that it is more true to life than a lot of blockbuster movies out there. I don't know about you, Mike, but like anything else, when you're a professional in a certain profession and you see a movie made about your profession, you're constantly going, "Oh, come on, that would never happen."
And if we have time at the end of this show, I'm gonna read the audience some quotes from influential folks who have made comment about this movie and how relevant it is to the actual practice of law. All right, let's get on. Let's get on to our second video clip. Before we do, let me introduce it. This is a subject that we have repeatedly hammered on this show, and that I repeatedly hammer on social media. And to anybody who will listen, I will sing it off the fjords. I will yodel it. I will do whatever needs to be done. Hashtag UpX2. Shut up and lawyer up. Invoke your rights. You have them, use them. Here's what happens, or what can happen, when you speak to the police. Go ahead and roll clip number 2.
Let's talk about that for a moment. You paid for the groceries. And then what?
We went out to the car, and that's it.
When'd you shoot him?
What?
At what point did you shoot the clerk?
I shot the clerk.
Yes, when did you shoot him?
I shot the clerk.
Hey, Dean, we need you out here. I'm in the middle of a damn confession here.
Whoa! Wait a minute!
Fast forward to the court scene.
He said, I shot the clerk. I asked him again. And again he said, I shot the clerk.
Your Honor, no further questions.
Mike, can I jump in here?
So go ahead, Ed.
This literally happened to one of my clients about 10 or 15 years ago. It was an underage girl. She was 15. He was, I think, 25 at the time. And I'm not making a moral judgment. Let's leave the moral judgments aside. Needless to say, the girl did not look, nor act, nor speak like a 15-year-old. But the point is this. He gets called in because Daddy, the father of the girl, calls the police on him. He gets pulled into the police station, and they ask him a bunch of questions, which one of them incriminated him. That's a story for another time, why you should never speak. But when they said to her, did you know she was 15? They put in the police report. When he came to see me, I said, but you confessed here. It says right there that they asked you if you knew she was 15, and your response was, yes, she's 15. He goes, I didn't say she's 15. I said, she's 15? Shocked. I was shocked. I said, well, this is exactly why you don't talk.
So I think the thing I want you guys to get out of this is, remember, this movie is from 1992, so we have to take it in context. In 92, there were no body cams. Nobody used them. Today, body cam is much more prevalent, although it's not everywhere all the time. We still get cases. Plenty of police departments don't use them. But that being said, if it's on body cam, if they were able to show the actual footage of the interrogation of Ralph Macchio by the sheriff, you would have understood the context, right? And then a jury could have seen that, and on cross-examination, a defense lawyer could have explained it away. But without the video, trying to explain that with any credibility is very difficult. I mean, would you agree with me? It would be hard sell.
It happened to me. It happened to me. There was no body cam when they asked my client. It wasn't recorded. None of that was recorded. And just as a side, for anyone out there who'll understand, what incriminated himself is with that specific charge of with a minor, any kind of sexual battery with a minor. Does not matter whether you knew or not that the child was a minor. Doesn't matter.
Right. Well, that's a strict liability offense.
Strict liability. So the first question they asked him was, do you know this girl? Yes. Have you had sex with her? Him thinking it was consensual. He said yes.
So
done.
Here's the takeaway from this. Again, the pro tip. If you don't speak to the police, if you invoke, this is an impossibility. They cannot have a confession unless you open up your yapper and give it to them. That's entirely on you.
Right.
So let's go up to our next clip. And before we play it, I call this the Ghostbusters clip. Who you gonna call? Okay, you get to make a call. You don't always get to make a call when you are physically arrested, but at some point in time after you're booked, and if the police like you, if you're cooperative with them, if they're in a good mood, if everybody's smooth, which is one of the many reasons that Ed and I always encourage you, even if the cops are 1,000% wrong, be cooperative and be pleasant. You don't have to talk. You don't have to give them anything, but don't give them attitude, because they're likely to allow you to have somebody come pick up your car instead of having it impounded.
Many times
or they're likely to allow you to use the telephone to call a loved one and let them know what's going on.
And can I say something? Many times they're giving you attitude for one of two reasons. One, not so nice. They're hoping you give them an attitude back and you get pissed off and you charge them so that they have an excuse to beat you. They're having a bad day and they just want to punch somebody. More often than not, the reason they're going to give you an attitude is to piss you off so you'll say something. That's why they do.
Let's roll clip number 3, if you don't mind. Who are you going to call?
Hello, Ma. We're in Wazoo. It's in Beecham County, Alabama, Ma. Not too good, Ma. We've been arrested. Ma, please. Ma, please. First of all, we didn't do it, all right? Murder. Ma, please, Ma, it's a mistake, all right? We must look like the guys who did it. I don't know what it is.
Tell them what we think is happening. What we think is happening.
Shut up. We think they're trying to set us up as patsies, Ma. You know how corrupt it is down here. They all know each other.
It's like the clans here. They're inbred. They sleep with your sisters. So let them do.
All right, Ma, listen. We got to get an attorney, and it's going to cost a lot of money. How much would an attorney cost?
A decent one? $50,000, $100,000?
50, 100,000. I know, Ma. I know. Don't use any attorney.
I think so.
He says he thinks so. Oh, he is? Well, that's a great idea. That's a great idea. You think he'll do it? What? We got an attorney in the family.
Great. Who?
My cousin Vinny.
Okay. So who are you going to call? Know your referrals, et cetera, et cetera. Let me say the first thing here is that may not be the most obvious thing. Let me reset my timer here. But it is an important thing. And that is any call that you make from the police station. In this particular scene in the movie, the cops are all standing around and they're obviously listening. But even if they're not, even if you're by yourself on a phone, they are listening. That call is being recorded. It is being monitored. Anything that you say can and will be used against you. You have no privilege. So be sure that when you do call from the police station, whomever you call, whether it's a loved one, a bondsman, a family member, your therapist, whoever it may very well be, you make sure that you know not to talk about the facts and circumstances of the case. You just need somebody to bond you out to help you to get out. Ed, anything you want to say?
That's the person you got to call. Don't call your lawyer. I don't know about you, but my friends, Mike, are constantly, when they're trying to reach me and I don't pick up the phone or they text me and I don't get back, they're constantly sending that little sarcastic text. It's a good thing I'm not getting arrested. Don't be calling me if you're getting arrested. Don't be calling Mike. You got to call somebody who's going to get you a bondsman.
So
that's the first call you got to make.
What we routinely tell folks, and we've done a show on bond, we've had Russ Walters on here, but what you should know about bond is unless you are being held on a non-bondable offense, or if there is some other hold that prevents your release. For example, you have a probation hold, you have an arrest warrant from another county or another state, you have a child support warrant, there's an ICE or an immigration hold placed upon you. Absent any of those things, the only person you need to reach is a bondsman or somebody who can call a bondsman to get you out. Lawyers are not bondsmen. We're generally not going to run down to the jail with a wad of cash to post your bond. And if you're not going to do it with a wad of cash, then you need a bondsman as a general rule. Now, that said, if you have a non-bondable offense or if you have a charge which requires a mandatory court appearance, right? For example, here in Florida, you cannot be released on bond on any domestic violence case, even a misdemeanor, without going in front of a judge. You must go to a bond hearing. Well, in that case, you might want to have a lawyer present. But shy of that, Ed's 1,000% right. The person you need to call, who are you going to call? Not Ghostbusters, not Ed Martinez, not your lawyer. You're going to call your bondsman or somebody who's going to reach out to a bondsman for you.
As much as we'd like to help you. And get a bondsman quick, as fast as you can, because the bondsman will tell you if it's a non-bondable. They'll look it up and say, hey, sorry, you got a hold from California. You know what the hell that's about? We'd be like, I don't know what that's about. Or sometimes these things don't come in the system fast enough. And a bondsman sometimes, rare, very rare. But and I'm not saying to circumvent the law, but a bondsman sometimes will bond people out
before that hits
the system, and then you're out.
So,
and then nobody bothers to put you back in. So, as long as you behave yourself and you're polite and you do things the right way, and you don't run from the cops, you don't try to avoid anybody, everything will be fine. The first person you need to call is a bondsman.
Let's get on to our clip number 4. Which or what lawyer is the right lawyer for your particular case? Go ahead, clip 4, if you don't mind.
Have you had any murder cases before?
No, this would be my first.
Your first. What kind of cases have you had? Assault and battery, armed robbery,
No.
Well, I expect he's done burglary, grand theft auto, drugs, right, Vin?
No. Nothing like that either.
What kind of law do you practice?
Well, up till now, personal injury.
Well, you're a trial attorney, right? I mean, personal injury trials.
Well, actually, this would be my first foray into the trial process. I haven't had to go to court yet. Knock on wood.
You haven't had to go to court yet. How long have you been practicing?
Almost 6 weeks.
But, man, you graduated from law school 6 years ago. What have you been doing since?
Studying for the bar.
6 years?
Uh-huh.
That's a lot of studying.
To be honest with you, I didn't pass my first time out.
That's okay. You probably passed the second time, huh?
I'm afraid not.
3 times a charm?
Not for me, it isn't. Nope. For me, 6 times was a charm.
6 times.
Okay, so before Ed offers commentary, I just want to say a couple things. One, in researching My Cousin Vinny, I found that this story was written in part based on an experience that the author had by meeting a guy who took the bar 13 times before he passed. So that was part of how that factored in. But I also want to say, and I think I mentioned that if we have enough time at the end, I'm going to read you some quotes. But a few of the things that My Cousin Vinny is actually really interestingly important for are that it has been highlighted as a film that highlights the fact that law school teaches law, but it does not teach how to practice law. And so some people are really, really good at the practice, whereas other people are really good at the academic, and others are good at both. So there's a difference between practical skill and analytical knowledge. And it's very interesting when you look at this particular clip. You're dealing with a guy who's never entered a courtroom as a lawyer, who's never tried a case, who's had no involvement in the criminal process, at least as a lawyer. We don't know if Vinny's ever been arrested. Although we do know that he did pass the bar, which means he at least got past the character and fitness portion. Right. So presumably if he was arrested, it wasn't that bad. But that being said, know your lawyer. So these two kids are now looking at a murder rap, and they've got this. And the other thing I want to mention is, a lot of people, this is very common, by the way. Why do they have their cousin representing them? Because they don't have the ability to hire anyone else, right? And if you watch the movie, you'll see the scene with the public defender and all that. But at the end of the day, this is a very common theme in the real world, right? It's not so much absurdity versus reality that many a criminal defendant has a limited budget, and therefore they're limited in their ability to put forth a defense. I have clients all the time who can't afford to hire me, so they don't. I have clients who can afford to hire me but can't afford to bring on certain experts that I recommend that are going to be beneficial to their case. I have clients who I think need to go into residential treatment sometimes, but they don't have insurance and they can't afford it privately. So sometimes you have other limitations like time to prepare. All of these things actually happen in the very real world. They're not Hollywood production. Ed?
Well, there's 2 things I want to point out. One, this is a movie. So this is one of the parts where it's a little bit absurd, a little bit. But I will point out something, and I don't know if you have a video clip of the very positive, true nature of why amount of experience in the trial as a trial lawyer doesn't necessarily carry over to the best trial lawyer. Yeah, he would need a little bit of experience, okay? Because there's certain things that he would need to be able to object to. And more importantly, because usually most prosecutors try to follow the law. They really do. They don't try to play fast and loose. It's frowned upon. It is very frowned upon in most offices, and judges really frown upon it as well because, they're supposed to be wearing the white hats. So it's very rare if you have to object to something the prosecutor's doing, they're probably doing it unintentionally. But defense attorneys, as a former prosecutor, I can tell you, we know they play fast and loose. That's the way they play. They're looking to make sure that it's 100% positively true, beyond a reasonable doubt, that this guy is guilty because they're going to prison. They're taking their liberties away. So they're always giving a little more latitude. So what really Vinny would need the experience is how to combat a prosecutor who objects to something he wants to do, right? Something that's important to prove that his client is either not guilty or not guilty beyond a reasonable doubt. And when a prosecutor objects, that he's got to know the right argument to make. And those are rules of evidence. And that comes from, like Michael says, the academic side. However, what Vinny does bring to the movie, which is 100% accurate, is a trial is really about a show. That's what it is. It's and do you have the clip where Macchio later tells this guy why they should go with Vinny? Because
I didn't put that clip on there.
Okay, but if you remember,
we have so many more.
Where he says to him, listen, Vinny comes from a family of arguers. He's been arguing his whole life. That part is true because one of the things you got to do in a trial is you got to think quick. And you got to, as Michael showed you later a video, you got to pivot, you got to adapt. And when you see you're losing the jury, you got to adapt. When you see that
we're going to get to
when the other side, let's say in this case the government, is making an argument that's really striking a chord, you got to be able to think on your feet quick on how to stop that. And Vinny has that, which you're born with. That's something that you're just born with. You can't teach that.
Let's go on to clip number 5. It's very important to know the law. Now, we know Vinny's not a criminal lawyer, right? So he's not really versed on criminal law or criminal procedure, but it's equally important to know your judge. Please roll clip number 5.
Mr. Gambini, are you mocking me with that outfit?
Mocking you? No, I'm not mocking you, Judge.
Then explain that outfit.
I bought a suit. You've seen it. Now it's covered in mud. This town doesn't have a 1-hour cleaners, so I had to buy a new suit. Except that the only store you could buy a new suit in has got the flu. You get that? The whole store got the flu. So I had to get this in a secondhand store. So it's either wear the leather jacket, which I know you hate, or this. So I wore this ridiculous thing for you.
You on drugs?
Drugs? No, I don't take drugs.
I don't like your attitude.
What else is new?
I'm holding you in contempt of court.
Oh, there's a fucking surprise.
What'd you say?
What?
What did you just say?
What'd I say? What?
So oftentimes, whether it's right or wrong, whether it's intentional or not, your judge becomes a problem in the case. And a defense attorney absolutely, unequivocally must stand up to the judge. That is black letter 101 criminal defense. You cannot, now you always have to be respectful. You always have to understand that the judge is the king or queen. They are the proverbial monarch of their courtroom. What they say goes. And there is a time to challenge the judge. It's called an appeal. And it happens at a later date. It's the same principle when we tell you, don't argue with the cop on the roadside, because the cop on the roadside has the ultimate roadside power. Same thing in court. Your lawyer needs to make a record. That's our job. We make a record, we preserve it in the event that an appeal is necessary. But what you don't do is you don't let the judge beat you up without creating your record. And you got to know your judge. In this case, Vinny got chewed out for showing up in court wearing a leather jacket, which is, how he dresses. So he had to buy a suit. And then his suit got screwed up and he winds up in that clown outfit. But again, it's the reason that he wore that clown outfit was, believe it or not, even though the judge thought he was mocking him, was because he knew the beating he would have gotten had he shown up wearing the leather again, right?
Right. Look, Michael's 100% correct. You cannot let a judge bully you. You can't let a judge shut you down. To be honest with you, I've always told people since I graduated from law school, that is what law school is. Law school is conditioning lawyers to be able to take an emotional beating and just keep going forward, because that's what really happens in a courtroom. The opposing counsel, the judge, and you got to be able to just let it roll right off your back and know you've got your goal. My goal is to make sure that I do what's best job I can for my client. And if I have to set the record, I set the record. One of the things that comes with experience and that you just can't teach is sometimes you have to pivot with the judge. So I may want a piece of evidence in, or I may argue something that I think the state shouldn't bring in, or whatever it is, and the judge rules against me. Not only got to lay my record, I still got another goal right now in this trial, right now in front of this jury. I need to get that evidence out to them somehow. So I got to pivot, and I got to do it, or I got to stop that evidence from getting to them. So I got to pivot. I can bring up one quick example. Years ago when I was a prosecutor, I needed to bring in a letter that was written in French from a bank in Africa. And I left for a vacation, and I left somebody in charge to get the certificate from the bank proving that that letter literally and actually came from them, and to get it translated to present it to the jury. I wanted to show to the jury why this Ponzi scheme fell apart. And that letter is the reason one of the people that was involved, the first person involved in the Ponzi scheme, that said, I want my money back. Introducing it would be awesome, right, Mike? Perfect. But I couldn't get it. When I got back, nothing was done. I knew now the other side, very good lawyer, was going to object. So what did I do? I pivoted, and I used the rules of evidence, the academic side. I argued to the court that that letter should come in still because it was effect on the listener, an exception to the hearsay rule. So I got it in anyway, because at the end of the day, all I really wanted was for the jury to hear this guy said, I don't trust that guy because of this letter. It was a lie. Everything was fake. So you've got to know who you're dealing with, but don't fight with them. I didn't fight with the judge. I wasn't going to sit there and cry like a baby. He wasn't going to give me more time. I wanted a continuance. He said, no, you know what it is, Judge Trayward. Very good judge, but, he's got his rules. And he said no more continuances. And when he says that, that's it. So I couldn't buy more time. I had to pivot and get that letter in.
Let's go on to number 6, ethics. In tandem with knowing your judge is not lying to your judge. This is a biggie. You cannot put false testimony in front of a judge. You cannot make false representations to a judge. I will give you an anecdote after, but let's go ahead and roll clip number 6.
Mr. Gambini, come in. I just got a fax from the New York State Office of Judicial Records. That they have no records of any Vincent Gambini ever trying any case in the entire state of New York.
You're not gonna find any records of Vincent LaGuardia Gambini practicing in any courts.
I just told you that.
You don't understand. See, 20 years ago, I became an actor. And there was this very prominent stage actor in New York. His name was Vincent Gambini. Maybe you heard of him.
No.
Never heard of him? Doesn't matter. Anyway, I had to change my name, which I did legally. So now I practice law under my legally changed stage name.
What name is that?
Jerry Gallo. You can still call me Gambini. Sorry.
And what name did you tell him?
Jerry Gallo.
Jerry Gallo? The big attorney?
Yeah.
think that was a smart move.
Yeah, well, the man is a seriously accomplished lawyer. He checks up on this guy, his name will show up all over the place.
His name was in the papers all last week.
I saw that.
You didn't actually read the articles.
No.
It's too bad.
Why is that?
Because he's dead.
Okay, so a couple of points I want to make real quick. The first is, obviously, as I said, you don't lie to your judge, but let me talk about clients, okay? There's always three sides to every criminal case, at least. There's what the police allege in their report, their basis of probable cause, which ultimately becomes the government's story or truth. There's the defendant's version of events, and then there's what a judge or a jury ultimately believes, which usually falls somewhere in the middle, albeit maybe skewed to one side or the other. I make it a practice to not ask my clients what happened until after I know what the government alleges. Why? Because once my client tells me his or her version of events, that's it. They don't get to change that story later. Because if they come to me 3 months later or 3 weeks later or 3 minutes later and say, oh, you know what? Forget what I told you. That doesn't sound good. Let me tell you what really happened. And by the way, I have somebody who can back it up. Now, all of a sudden, I'm in a position where I have to question whether or not my client is trying to commit perjury, and I cannot be a party to that. So that's one thing I wanted to point out. Basically, was you got to be careful about what you say, because ultimately, once you say it, you're locked into it. Go ahead, Ed.
Yeah, and just so we're crystal clear, whether I agree with Mike 100%, but it goes beyond just our personal moral beliefs. This is by the Florida bar. This is the ABA. Everybody, you cannot put a person on the stand if you believe that they're about to commit perjury. As a lawyer, that means prosecutors can't do it. That means we can't do it. So, if my client were to come to me and tell me later I want to get on the stand and lie, I'd say no, I can't be a part of that. Just sit there. You're not going to testify, and let's see what happens with the evidence. But I can't put you on because ethically we're bound, and secondly, morally, I would never lie to anybody. And I have found, Mike, let me tell you something. I got to tell you, you and I both have been doing this for a lot of years, and we know lawyers that lie about stupid things.
Okay? Well, they have reputations. Like
forgetting to show up to court one day. Whatever, showing up late. They come up with all these stupid lies. And I got to tell you, man, I have never once has it failed. Everything works out fine when I tell the judge. I've showed up to court the day after and been like, Judge, I am so sorry. I totally forgot to come to your courtroom. I don't know. I just forgot. I overslept, Judge. I remember in federal court, the first federal trial I ever had, I had like 6 co-defendants. We had 6 other lawyers, and I showed up 15 minutes late. And when I showed up, the federal judge looked at me and said, good of you to join us, Mr. Martinez. I said, I know, Judge, I'm sorry. It took a little longer to get ready this morning than normal. That's all I said. And you know what he said to me? Okay, no problem. Have a seat. Let's get started. So I have always found that the truth works if it really is the truth. And if you're really doing what you're supposed to be trying to do, right? If you're, pardon my French, fucking off, you're not going to be able to tell the judge, I was fucking off. But if you're really trying to get to court on time and there's an accident, or you're running late, or your alarm clock, or your dog puked before you left and you had to clean it, just tell.
Well, in this case, what Vinny did was he did what's called pro hoc vice admission. You're licensed as a lawyer in the state where you take the bar exam. Now, of course, you can have multiple licenses in multiple states, but be that as it may, let's just take our instance and say if you're a Florida lawyer, you're licensed by the Florida bar, you can practice law anywhere in the state of Florida. But if you want to practice law anywhere else, you either have to pass the bar or you have to get special permission to appear, which is called pro hoc vice admission. I've done this many times over the course of my career where I've gotten permission to practice outside of the state of Florida. And the basis for doing that is providing the court with your resume, your qualifications, a certificate of good standing from the bar association that licensed you. And some judges require recommendations and or a sponsoring attorney from their own jurisdiction. But be all that as it may, that's what Vinny did in this case. He got permission to use his New York bar card in Alabama, but he did it under a phony name because he knew that if they looked him up under his name, he'd have no qualifications. So he gave him a name of somebody who would show up qualified, which means he knowingly and intentionally lied to the judge, which is a subplot in this movie. But let me get on to the next. We're going to show you 2 clips in a row, back to back. And this is the cross-examination clips. And the reason that we're going to do them back to back is because it goes to something that Ed said earlier about Vinny's innate ability, his arguing ability, his natural talent of being able to pivot. And if you watch the first examination, you'll see how he treats the witness as opposed to the second examination, how he treats a completely different witness. They're both cross-examination situations. That's where the defense attorney is challenging a government witness after that witness has already offered testimony to the pursuant to the prosecutor state's evidence. So let's show these two back to back, and then Ed, you can talk about the contrast. Clip number 7A, please.
Hey, how you doing? Hey, Mr. Crane, what are these pictures of?
My house and stuff.
House and stuff. And what is this brown stuff on the windows?
Dirt.
Dirt? What is this rusty, dusty, dirty-looking thing over your window?
It's a screen.
A screen. It's a screen. And what are these really big things right in the middle of your view from the window of your kitchen to the sack of suds? What do we call these big things?
Trees.
Trees, that's right. Don't be afraid to shout them right out when you know. Now, what are these thousands of little things that are on trees?
Leaves.
Leaves. And these bushy things between the trees.
Bushes.
Bushes. Right. So, Mr. Crane, you could positively identify the defendants for a moment of 2 seconds, looking through this dirty window, this crud-covered screen, these trees with all these leaves on them, and I don't know how many bushes.
It was like 5.
Don't forget this one and this one.
7 bushes.
7 bushes. So, what do you think? Is it possible you just saw 2 guys in a green convertible and not necessarily these 2 particular guys?
Well, I suppose.
I'm finished with this guy.
Finish with this guy.
Go ahead and play the next clip, 7B, please.
Finish with this guy.
Mrs. Riley, when you saw the defendants, were you wearing your glasses?
Yes, I was.
Over here, dear. Would you mind putting your glasses on for us, please? Whoa. How long you been wearing glasses?
Since I was 6.
Have they always been that thick?
Oh, no, they got thicker over the years.
So as your eyes have gotten more and more out of whack as you've gotten older, how many different levels of thickness have you gone through?
Oh, I don't know. Over 60 years, maybe 10 times.
Maybe you're ready for a thicker set.
Oh, no. I think they're okay.
Maybe we should make sure. Let's check it out. Now, how far were the defendants from you when you saw them entering the sack of suds?
About 100 feet.
100 feet. Would you hold this, please? Thank you. Sorry, excuse me. Sorry. Okay, this is 50 feet. That's half the distance. How many fingers am I holding up?
Let the record show that counsel is holding up 2 fingers.
Your Honor, please, huh?
Oh. Sorry.
Now, Mrs. Riley, and only Mrs. Riley. How many fingers am I holding up now?
Both.
What do you think now, dear?
Thinking of getting thicker glasses.
Thank you.
All right, Ed, I'm going to let you run with this in a minute, but I just want to point this out. A couple of things. One, very different approaches to these two witnesses, right? And two, the use of a demonstrative aid to effectively, demonstrative aids. He used the photographs for the first witness and he used the ruler for the second. Incredibly powerful